Welcome to another edition of Crime News with Mark Solomon. Today we're starting part 2 of a 3-part series on a deep dive on the opposition filed to the sentencing, the post-conviction motions filed by the defense. We are going over everything the prosecution has written for the most part. Stay tuned. Now, one of the other questions that keeps coming up is whether or not this should have been tried in the county where it was tried or whether it should have been tried in a different venue. Now, I always tell people trying to win on a venue issue is really hard. It's usually a losing argument. Here in Colorado, you either object to it and give notice many weeks before trial, or you've waived the argument. In most cases, objecting to the venue just moves your trial to a different place. And in this particular case, the prosecutor is saying that moving it to a different county in Minnesota wouldn't have changed the outcome because everybody in Minnesota and pretty much everybody in the United States was looking at this case. And so moving it to a different venue wouldn't have changed a thing. So I'm going to move on to the actual reasons why he said this. He said he has not met his burden to establish that the court erred in holding a trial in Hennepin County, and he says there's 4 really good reasons. First, prospective jurors can be presumed cannot be presumed partial solely on the basis of exposure to pretrial publicity. You have to prove actual prejudice. Second, the Minnesota Supreme Court repeatedly affirmed district court's denial of a change of venue, whereas here the pretrial coverage has affected the entire state. As I was saying, it affected the entire country. Third, the court properly exercised its sound discretion to try the case in Hennepin County by exposing extensive procedures to safeguard the defendant's right to a fair trial. And they talked about, the jury questionnaires, the extensive voir dire, and all of the questions that went into picking these particular jurors in the case. Fourth, in its November order denying a request for venue change, the court also properly determined that it could better ensure the safety of the trial participants in the Hennepin County Government Center. As in moving them to another county, that court couldn't guarantee that moving them back and forth from home to the county where the trial might have been held was actually safe for the witnesses and so forth. And because of that, prosecutor goes on to state a legal standard for which has to be met. The defendant must show that the jurors who tried this case were actually prejudiced by publicity. And here, he has not and cannot meet his burden to establish actual prejudice. Remember, these are arguments by the prosecutor. Each juror here was carefully vetted in voir dire and affirmed in his or her impartiality under oath. The defendant offers no evidence to the contrary. But again, there can be arguments made and inferences made, and that's up to a judge to make that ultimate decision. And here, none of the defendant's counter arguments are remotely convincing. Little bit of extreme argument there, but let's keep going. Let's actually move on. There's a lot of argument. If you can see from the bar at the top, this is a very long brief, and I'm not going over all of it. I'm going over the parts I thought you'd find most interesting. The court did not err in declining to fully sequester the jury. There's some good back and forth on this channel in the comments about whether or not sequestering the jury before deliberation would be a good issue for appeal. And clearly, this is one they are actively litigating here at the post-conviction part, but before sentencing. So the court was well within its discretion to decline fully sequester a jury and instead preserve jury anonymity, admonish jurors who avoid media, and sequester the jury overnight during deliberations. And he talks about this, and he gives reasons. First, the defendant acknowledges and the court repeatedly admonished jurors to avoid news. Whether they did or not is another question. The court's anonymity order and instructions to avoid discussing the case with anybody was designed to protect the jurors from harassment, which is, again, an outside influence on the jury that would have affected their verdict. Absolutely. Finally, the defendant again fails to offer any evidence that he was prejudiced by the court's decision. And again, he's making the assumption that something could have happened, but he's not actually presenting any evidence that it did happen. And that's a common theme in defense prosecution arguments. And that's going to be the end of part 2 of this 3-part deep dive into the post-conviction motions. Stick around, watch part 3. But until then, if you have any comments, issues, questions, anything, put them in the comments below. Tag me on Twitter or email me. Love to hear your thoughts. Thanks for watching.